Perfect. So we can start. Lucia?
Yes, everything works perfectly.
Everything works perfectly? Yes, but why there is your image, your picture in the center of the screen? That's true? Okay, perfect. Perfect, thank you very much. Good afternoon and welcome you all to this legal and regulatory session. First of all, let me introduce myself. I am Francesca Mattassoglio. I'm an associate professor of economic law at Bicocca University, where I teach banking and financial law. I'm also a member of the Crypto Asset Lab. And today, in this session, as scheduled, will be presented three very interesting papers, which address three relevant issues regarding the crypto asset regulation. And every presentation will take about 20 minutes. And finally, we will have 20 minutes more dedicated to questions and answers. So if you could ask a question writing in our chat or by voice. In this case, just raise your hand in our chat and we'll open your microphone as soon as possible. But now I don't want to take up your time and I will immediately give the floor to the first speaker. Our first speaker is Riccardo de Caria. Riccardo is an assistant professor of comparative public law at the University of Turin and is also co-chair of the Italian hub of the European Law Institute. The title of his paper is The Classification of Tokens and its Regulatory Implication. So I will give the floor to Riccardo and please, it's your turn. Thank you.
Well, thank you. Thank you very much first of all, for the invitation and also for the perfectly flawless organization. It's unbelievable to start at 4 p.m. It's a conference that was supposed to start at 4 p.m. I'm not used to that punctuality and it's great. Anyway, without further ado, I think we can start our session. I have written this paper on the classification of tokens and its regulatory implications for a very specific reason. I realized that, there's a lot of discussion about the tokenized economy, about the regulatory approach to the tokenized economy, also from a comparative perspective, which is my own favorite area of investigation academic-wise, but I have come across to some confusion. And I have realized that, to me, the terminology used is not always clear, it's not always uniform, according to different operators, to different jurisdictions, to scholars or to supervisory authorities, the terminology sometimes change. And so I thought it would be useful to take a step back and to survey the existing definitions of tokens from a regulatory perspective and try to help the scholars in reaching some agreement on the employed categories and to develop some working definitions so that every regulatory discussion is facilitated from this perspective. At least that's my my goal. So very briefly, I will go over the different classifications that have been employed, particularly by the SEC in the United States and FINMA in Switzerland, that are two of the supervisory authorities that have most actively engaged in a discussion of the subject. I will look at how they have defined the categories of tokens that they have developed. Then I will go on and look at the regulatory consequences of the taxonomy that they have developed. And finally, I will offer some remarks at the end. Before getting into the analysis, there is still one preliminary note to cover. So we are discussing the categories of tokens, but to be sure, probably even the definition of token itself is not always uniform across the board. So I thought that, I mean, it's good to spend a few moments to talk about it. The word token arose from the, I mean, in the IT domain to address, to define, to refer to something that represents something else. So typically tokenization is a process aimed at protecting some important data that is not intended to be disclosed. And then this process acts through, I mean, is implemented through the conversion of the data that needs to be transferred, but without disclosing it. So this data is transferred into a non-significant equivalent that can be transmitted without revealing the original content. And this is done typically thanks to cryptography. The feature, the technical and economic feature of this process is, implies a very large amount of economic effort in order to go back to the original data if one doesn't know the cryptographic key in order to understand what the original data was. So this was a process that actually didn't, I mean, came out before the rise of the blockchain world. Then it was employed in the blockchain environment, and in the blockchain environment, it refers, I mean, tokenization refers to the process of converting wealth into digital tokens, which are then issued on platforms based on a blockchain via smart contract. So this is just to say that tokenization is something that predates the blockchain revolution, but then it was employed with particular success in the blockchain revolution, and we are discussing tokenization and classification of tokens precisely within the blockchain environment. So anyway, moving to the actual analysis and to the blockchain world, typically, if we look at non-scientific, or I mean journalistic publications, the most common classification of tokens divides them into security tokens and utility tokens. These are the two most common categories, and sometimes you also hear or read about payment tokens or cryptocurrencies. So in different quasi-legal environments, you hear and read about some more categories. So these two are complemented by some others. So on top of payment tokens, you have currency tokens, investment tokens, equity tokens, asset tokens, commodity tokens, exchange tokens. So you start to have a lot of definitions. Some of them appear to be falling down the two broader ones, but the picture is not always clear. So this is when things start becoming a little bit fuzzy. And so this is why I think some more some deeper study into the subject is warranted. If you even look at the second edition of a book on the tokenized economy by Voshmir, it even lists even more categories. It speaks about stable tokens, again, asset tokens or social media tokens, attention tokens, purpose-driven tokens, fractional ownership tokens, privacy tokens, lending tokens. Then central bank digital currencies are considered a category in itself, and also Libra, Facebook's Libra is considered a category of token. So the problem is, do we really have so many categories of tokens, or these labels actually do not correspond to self-standing categories from an IT or legal perspective? They are simply very good marketing tools. They are commercial labels that do not actually correspond to self-standing regulatory categories. And I think the latter is the case. So they're not actual categories. They're just labels good for marketing, which is nothing bad. But I mean, for our purposes, the categories are less. And what matters is arguably the purpose of the token. When the token is issued, we need to look at the purpose. And if we do that, we will tend to realize that the purpose can be traced back to three different options that can overlap, as we will see. But typically, you can have a token that is issued to act as currency, or it is issued to work as an investment opportunity for those who subscribe it, or it can simply afford the right to claim some benefits or services from the issuer. So these are the three main goals. So how does the SEC deal with this problem? Typically, we are used to say, I mean, you read a lot of articles saying, okay, the SEC usually divides tokens in cryptocurrencies, utility tokens, and security tokens, except that it doesn't. If you look at the main regulatory document of the SEC, which is a framework for investment contract analysis of digital assets that dates back to April of last year, it actually uses a different terminology. It speaks about, as the title says, of digital assets. And in this framework, the word digital assets is referred to an asset that is issued and transferred using distributed ledger or blockchain technology. So where, I mean, it's something that is relevant for us. And it includes, but it's not limited to, so-called virtual currencies, coins, and tokens. So it doesn't mention security tokens or utility tokens. What the SEC is concerned with is to analyze when digital assets must be considered securities. So this is what concerns the SEC. When are digital asset securities? So what's most important for the SEC is to figure out that from their regulatory perspective. For our purposes, we can derive a contrario that when a token doesn't fall under the securities category, then it means that it will fall under a different category, which is, however, not defined in this document. Anyway, to determine if the token in question falls within the notion of security, or to be sure in the subcategory of investment contract, the SEC refers to the very well-known Howey test. The Howey test works with three prongs, as is probably well known to the audience. So an investment contract is triggered when there are three elements: when there is an investment of money, when the investment of money is made in a common enterprise, and most importantly, when this is done with a reasonable expectation of profits to be derived from the efforts of others. In order to qualify as a security, a token needs to meet all the three criteria. If just one is missing, it will not be a security token. But if all three are triggered, then the token will have to be considered a security token, and typically the analysis falls on the third prong. If you look at the document, the framework, the SEC framework, there's no analysis of utility tokens. So as I was anticipating, their qualification can be obtained residually. It's in a residual manner. They are what is not a security token, and so they appear to be unregulated and lawful, at least at the moment. Apparently, since there's no further clarification, the residual category also includes cryptocurrencies. And the SEC says that to the extent that the virtual currency can immediately be used to make payments in a wide variety of contexts or acts as a substitute for real or fiat currency, it will tend to fall in the cases of use or consumption purposes, which means it will not trigger the third prong of the Howey test, and it means it will fall outside the securities token category, and therefore it would seem to fall under these residual categories of non-security tokens. Let's move on to the FINMA taxonomy that is contained in these guidelines that were issued in February 2018. Correctly, the FINMA starts from a similar consideration to the one that with which I opened my presentation today. There is no generally recognized classification of ICOs. and the tokens that result from them. So what FIMNA does in light of this observation is it bases its own approach to categorization on the underlying economic function of the token. This, to a certain extent, corresponds to the third prong of the Howey test, and I think this is a very wise approach. What matters is the underlying economic function, as I was making the case at the beginning of my presentation. This is good, I think, because it avoids the risk of circularity. I define circularity here as the error of defining a token based not on its economic function, but on its regulatory treatment. Instead, the regulatory treatment should be the consequence of a definition of defining a token according to its economic features. And then, so once we have defined a token in a certain way, then as a consequence, we apply a certain regulatory framework to that category, which should not fall into the circularity reasoning, which is a logical mistake. FINMA adopts, in fact, the common tripartition between payment tokens, utility tokens, and asset tokens. It doesn't speak about security tokens, but of asset tokens. Payment tokens correspond to cryptocurrencies, and here they're clearly as self-standing categories, and they're defined as tokens which are intended to be used now or in the future as a means of payment, okay, for acquiring goods or services, or as a means of money or value transfer. So FINMA clearly says that it will not treat payment tokens as securities. Even though some experts would advise it to do that, it will not do it as the SEC won't do it either. Utility tokens are not a residual category for FINMA. They are intended to provide access digitally to an application or service by means of a blockchain-based infrastructure. I underlined here blockchain-based infrastructure because I find it a little bit confusing that the reference to blockchain is here, is only present here in the definition of utility tokens, not upstream in the broader definition of tokens, but that's I mean, that's a minor problem. Moving to asset tokens, they represent assets such as debt or equity claim on the issuer. Asset tokens promise, for example, a share in a future company earnings or future capital flow. In terms of their economic function, again, therefore, these tokens are analogous to equities, bonds, or derivatives. Tokens which enable physical assets to be traded on the blockchain also fall into these categories. So I think this is very good because it allows us to clearly conclude that the tokenization, asset tokenization, physical asset tokenization falls falls under the asset token. So I think the expression asset token is quite appropriate, even better than security tokens, because it clearly encompasses also physical goods that can be tokenized. And also, as I said, it avoids circularity. So kudos to FINMA. FINMA also makes the right point that the individual token classifications are not mutually exclusive. And I think this is really correct, of course. But the slight problem I can see is that it applies the expression hybrid tokens only with regard to the case when asset tokens on one hand and utility tokens on the other hand are simultaneously classified also as payment tokens. It's a bit misleading because in my head, I mean, hybrid tokens could also be imply an overlap between utility and security tokens, which is something fairly common. So I think the expression here could be improved. Few words finally, and I will coming closer to the end of my presentation. So what's the impact of these definitions? Well, as regards payment tokens and cryptocurrencies, if we look at the SEC, there's a little discrepancy between what the SEC says. As we saw, it tends to trace cryptocurrencies back to the securities category. Some other authorities, like the CFTC, qualifies them as commodities. The IRS it also says that it will tax cryptocurrencies as property and not a commodity. So there's a little confusion here in the American world about the regulatory treatment of payment tokens and cryptocurrencies. Some further confusion also comes from the very famous Bitcoin VAT case of the European Court of Justice, that, as is well known to probably all of you, said that transactions implying the exchange of Bitcoin for fiat coins should be considered exempt from VAT because they fall under the exemption for currency, banknotes, and coin used as a legal tender. I think this is very favorable for operators, but it always struck me as in contrast with the cryptocurrency's nature of some alternative instrument to fiat currency. So I couldn't really make, true sense of this judgment on cryptocurrencies. Moving on to payment tokens, for FINMA, they simply are considered a means of payment, and so they are subject to anti-money laundering legislation. I think FINMA, as for payment tokens, stands out as the most precise and consistent approach. As for utility tokens, they are the least regulated category. So the problem with utility tokens is that since in most jurisdictions, even though with some notable exceptions, they're lawful, they simply fall down civil and corporate law rules, but not under specific financial regulation. There's an incentive for issuers to qualify tokens as utility tokens in order to avoid compliance with security tokens regulation. So that's essentially the more problematic issue about utility tokens. The problem is that typically financial supervisory authorities will consider that an utility token is actually an utility token if their sole purpose is to confer digital assets rights to an application of service. So if there's also some investment purpose, it will trigger the security token discipline. So the investment purpose needs to be missing entirely, okay? If we look at the SEC enforcement practice, we see a restrictive view. So an ICO qualifies for an exemption from security rules only in limited cases, and it's all pretty much equivalent to what FINMA does. The point is that determining whether a transaction involves a security does not turn on labeling. So it's not important how the issuer qualify their token. What's important is the underlying economic reality of the operation. So finally, security tokens, they tend to imply need for registration with supervisory authorities, sometimes licensing requirements, and typically the need to provide some pieces of information typically contained in the prospectus. So this can be quite burdensome in terms of compliance, and this is why people tend to, issuers try to escape from security tokens regulation, and this is why the SEC and also FINMA have been quite inflexible in their enforcement practice. So to conclude, I think the picture is still somewhat fuzzy and confusing in terms of terminology. There are several commercial qualifications of tokens, as we have seen, but they do not correspond to a difference that has meaning in terms of substance, IT substance, or legal substance. Several supervisory authorities have tried to regulate ICOs, but they do not always have done the step of making an adequate classification of coins or tokens before doing that. We see that SEC and FINMA have done that. There are many similarities, but there are also some differences. Apart from the terminology, the change between assets and security tokens, we also saw that utility tokens are a residual category for SEC, whereas they are a self-standing category for FINMA, and also that cryptocurrencies tend to fall down the category of securities or commodities in the US, whereas they qualify as means of payment in Switzerland. So I think there is still some need for further clarity for operators. So I think that this research is worth continuing. So thank you very much for your attention.
Thank you very much, Riccardo, for your presentation and also for keeping to your speaking time. I believe that the token classification entails a very crucial point for an effective crypto asset regulation. And I agree with you on the confusion there are now about this point in the USA area, also in Europe, generally speaking. And we come back on this issue later, but now it's time to move on to our second paper presented by Eduardo Silva de Freitas, who is a PhD researcher at Erasmus University, Rotterdam, where he's working on the subject of crowdfunding civil justice. Today, he presented a paper entitled Cryptocurrency Regulation in the EU AML Regime, the Path Towards Effective Harmonization. So please, Eduardo, the floor is yours.
Hello. I'll just share my slides here. Okay, can you see my slides, Francesca?
Perfect.
Okay,
Your
so
slide.
Good afternoon, everyone. Thank you for coming. I will present to you today my research, Cryptocurrency Regulation in the EU AML Regime. It's a paper resulting from my master's thesis. And without further ado, the research problem we intended to address is the reason and the impacts of this asymmetrical harmonization, which is taking place in the European Union as regards the AML policies targeting cryptocurrencies. This headline, which I highlight here from the Financial Accountant in 2019, puts the mediatic attention of this problem in place. And why exactly is this a problem? Well, in my view, it's because of the two goals that are recognized in the EU AML regime. The second, that is the functioning of an internal market founded on clear-cut rules, becomes undermined if certainty is not achieved in terms of what you expect when you are operating this type of service. And it will become more clear later on the presentation what are the types of burdens that are being encountered. So what are cryptocurrencies exactly? In my view, they resemble an intersection between two broader concepts in some narrower forms, which you can find them, that are virtual currency schemes and tokens as well. The classification I put here of tokens is pretty much similar to that Riccardo just presented when he spoke about FINMA. So I don't believe I need to repeat that in detail, but of my interest here are currency tokens, which also, as Riccardo said, they are used mainly as means of payment. And in terms of the VC schemes, the categories that you can narrow down from this broader one are closed virtual currency schemes, which are essentially in-game money, which you cannot, in principle, exchange for fiat currency. Unilateral virtual currency schemes, which once you bought, you can only use for a specific set of purposes, and you also cannot switch back into fiat currencies. And finally, we have bilateral virtual currencies, which are also used mainly as means of payment, but then you can exchange back and forth from and to fiat currency and use them for buying any type of asset or service. As regards the money laundering risks precisely posed by this type of asset, I think the mainstream one is the anonymity/pseudonymity issue, which is linked to the fact that the information, sorry, I think my slide has came down. Yes, sorry, I'm back. which is precisely linked to the fact that in the blockchain, not many information regarding the transaction is displayed, only the public keys of the transactors and the amount transacted, but these public keys are easily available, so you can always use a different public key for each transaction, which curbs traceability even more. And the fact that these transactions can take place real time. So not only they disrupt the traditional approach of AML policies that's focusing on intermediaries, because intermediaries are only necessary when you want to exchange them back to fiat currencies, and considering the speed of the transaction, there is no meaningful time for competent authorities to take any action. As regards their legal characterization under the EU AML regime, well, legal discussion started back when AMLD3 was still in force in terms of its personal scope, more specifically currency exchange providers. Some scholarship has tried to argue that they would fall under the financial institutions concept of AMLD3, more specifically the Bureau of Exchanges, comparing virtual currency exchange services with normal bureaus of exchange, like from dollar to euro. But this is not in line with the FATF's understanding regarding bureaus of exchange, and the goal of AMLD3 was to implement the FATF recommendations. They specifically excluded what at the time they called digital currency out of the scope of their report on bureaus of exchange. In terms of the material scope, the asset itself, the cryptocurrency, was deemed to fall under the category of property because it entailed these other three narrower categories of assets of every kind, incorporeal or intangible assets. So that's where legal scholarship argued that the cryptocurrency itself would be regulated by AMLD3. AMLD4 was a little bit different because there was legislative discussion on its inclusion, its express inclusion in the European Union anti-money laundering regime in a post-Charlie Hebdo era, if you can call it that way. There was investigation on the possibility that some of the terrorist attacks involved the use of cryptocurrencies, but no meaningful evidence was found. And in the end, cryptocurrencies were not expressly included in the text. In terms of its personal scope, again, there was argument that it would fall under the category of financial institutions, but this time not Bureau of Exchange, but under the concept of credit institutions in the function that they, among all of the functions listed on the Capital Requirements Directive for the specific function of administering payment services. And to do justice, one court in Estonia, following this understanding, has judged that their national AML implementing legislation indeed covered cryptocurrency exchange providers. In terms of material scope, the argument was exactly the same as AMLD3, since property was also the term used by AMLD4, and the categories that they thought cryptocurrencies did fall under was assets of every kind, incorporeal or intangible. And we get to AMLD5 with this definition of virtual currency provided here, which is, as we'll see, has some of its shortcomings, but attempted to somehow resemble the FATF's definition, but wasn't very successful in that. What is more important here is what I highlighted there, that they are mainly used as means of exchange, which especially for regulating other tokens in its coverage falls a little short, as we'll see in a minute. Are out of the scope of AMLD5 closed VC schemes, what I called later as in-game money, so they are not regulated. Unilateral VC schemes are also not regulated because the directive itself uses the term of used in a very limited way, and in legal scholarship understand that that's the case of unilateral VC schemes. And besides the goals of the EU AML regime that I mentioned earlier, another reason why specifically the harmonization of AML policies targeting cryptocurrency was necessary was to fill the gap of the directives in tackling the money laundering risk of cryptocurrency that is essentially the anonymity feature that they pose. But the directive did not, and to be honest, I'm not sure if it even could, abandon the gatekeeper approach, because the two intermediaries included in the regime were cryptocurrency exchange providers and custodian wallet providers. So this is how we are submitting who we can to customer due diligence and try to, well, scrutinize cryptocurrency transactions in AML terms. So what are the shortcomings precisely? The first one is the coverage of initial coin offerings, because as I just said, the definition is very precise in saying that virtual currencies are defined as such under the directive when they can be used as means of exchange. Even though recital 10 of the directive refers to the possibility of they being used as investment, I don't see, and there is how other authors also see, that you could interpret the legislation itself as being more far-reaching than the recital. Sorry, the recital as being more far-reaching than the legislation. And I add to that the Court of Justice of the European Union's understanding that recitals are not binding at all. And this is one area where we can more concretely see how asymmetrical harmonization is taking place within the Union. France, Italy, and the UK all have included, because it's a directive, so minimum harmonization, investment as one use under which the category of cryptocurrencies will reach. But for example, another EU member state, Bulgaria, didn't. Another matter regarding initial coin offerings is the definition of exchange services, because the directive only covers fiat to crypto trade when dealing with exchange service providers. And since ICOs can receive any asset as consideration, they will not always fall under the category of exchange providers under the directive, and that's the understanding of ESMA, and that's why ESMA recommends the explicit inclusion of initial coin offerings under the EU AML regime. Again, another very concrete example of asymmetrical harmonization taking place. 3 countries to where my research went included not only crypto to crypto, but in some cases also the one virtual currency into the same virtual currency, as you understand later, in their regimes, but such as UK, Italy, and Germany. But again, one example just to show that there are some countries which are indeed only implementing the minimum required. Bulgaria did not. Again, this lack of crypto to crypto regulation also undermines the regime, because Tumblr services are not covered. Tumblr services are services which they receive the cryptocurrency from the user. They spread it among a lot of other public keys, and then they, after give it back to the user. So you add a lot of transactions to the record and further curbs traceability. Again, a concrete example, 3 countries included crypto to crypto exchanges in their regime, but the famous example of Bulgaria, which only copied the directive, did not. And how does this exactly imply? Well, jurisdiction matters, as the competent of FYU for scrutinizing AML matters is a problem in the EU for some time now. But to be short, AMLD3 said that any service provider operating in a host member state only had to submit suspicious transactions reports to the FYU of its home member state. The Court of Justice overruled that and say, no, this is not compatible with the goals of the EU AML regime. But this ruling was then overridden again by Parliament when AMLD4 was enacted, and they said, no, you have to submit to only to the FIU of the home member state information regarding AML. So where does this leave us on cryptocurrency matters? Well, if, for example, one cryptocurrency exchange provider is operating in the UK, but its home member state is Bulgaria, and it only deals with crypto to crypto trades, the UK cannot at all request any information directly from the service provider. It can only request from the Bulgarian FIU, but the Bulgarian FIU cannot request from from the service operator under its jurisdiction because it's not a regulated entity there. And Article 53 of the directive is very clear in stating that the home member state's FIU only has to use the powers available in its legislation. So basically, it becomes an unsupervised entity in a territory where it would be only because, well, this asymmetrical harmonization is taking place given how imprecise the directive was in its ambition to really tackle this matter. That's why I propose that the possibility contained in Article 45.9 of the AML directive, which is applicable to e-money issuers, be extended to cryptocurrency related services as well, because then you can rely on the central contact point and always request information, suspicious transactions reports in the by the FIU of the host member state, and you will have much more ability to investigate predicate offenses and etc. I believe this way this problem would be tackled with much more efficiently. And in terms of enforcement, and I'm already going to the end of my presentation. I'm sorry if I spoke a little fast. The decentralized exchanges were not included. They are rather passive. They are rather passive role in cryptocurrency trade since they only matchmake. They only meet the demands and needs of cryptocurrency users. So the ECB only recommends that later on they be submitted to some guidelines such as transparency, security against malware, and other types of security standards to protect the operation. And as to this of privacy coins, which by definition always use a public key for each different transaction, they are prohibited in European Union territory because the respective exchange service will always have to perform CDD, and if they cannot properly identify the persons involved, they are forbidden to carry on the transaction. As regards the future impacts of the markets in crypto assets proposal, which is now and is being elaborated on, the money laundering matters that were dealt with were mainly the withdrawal of authorization for issuers of asset reference tokens and also service providers. So as long as these issuers are and these asset reference tokens do not qualify as e-money, because some stable coins can qualify as e-money depending on their specific characteristics. As soon as any board member or the entity itself is in breach of any national AML law implementing the AMLD4, the authorization for functioning will be withdrawn. And if this type of entities is being acquired and the competent authority is evaluating the acquisition in case there is breach or potential for breach of AML provisions, the acquisition cannot go on and the competent authority has the right to refuse its implementation. But just one thing that I want to add here is that, for example, it's not very clear that issuers are regulated entities at all in every national AML legislation implementing AMLD4, because as I said earlier, investment is a matter of choice. If the country wants to expand their reach, because I believe almost every scholar who written on the topic says that investment tokens are not covered by AMLD4. In Italy, for example, it is, but not everywhere. So how can you possibly breach a legislation which does not apply to you? You cannot. So it is a little shortcoming that the AML directive is causing in the reach of the MICA proposal in AML matters, in my view. Well, that was my presentation. Again, I'm sorry if I spoke a little too fast. Comments and questions are all welcome. And I give the floor back to you, Francesca.
Thank you very much, Eduardo, for your presentation, and it's not a problem. You're fast speaking. Don't worry about it. We will come back to these very important issues concerning the AML question maybe later, because also in this case, I think that this issue regarding crypto assets are very important. And also the EU regulation proposal, MiCA, that you have already mentioned in your final slide, underline that any legislation adopted is in this field should also contribute to the objective of combating money laundering and financing of terrorism. So this is a very crucial point, and we will come back to you also with some question at the end. Thank you for now. And finally, we can move on to the third and final paper presented by Salvatore Luciano Furnari, which is a PhD student at University of Rome, Tor Vergata. And in this case, the paper concerned the use of the blockchain technology to the company in the company law. And the title of the paper presented by Salvatore, which is written by Salvatore and Professor Raffaele Lener, is Company Law During the Blockchain Revolution, the Rise of CorpTech. Sorry. Please, Salvatore, the floor is yours. Thank you.
Thank you, Francesca, for the kind presentation. I will try to share my slides. Okay. I hope you can see it. You can see them?
Perfect. We can see it.
Okay. So the title of this paper is Company Law During the Blockchain Revolution, the Rise of CorpTech. These are the main topics that we will discuss in this presentation. So we will talk about the organization of companies' participations. We will talk about the possibility of exercising rights using DLT systems, where in this paper we will use the term DLT for mentioning all the blockchain environments. And at the end, we will see if DLT can be used against the perils and the dangers of deepfake technology. So the main scope of this paper was verifying if the so-called CorpTech myth can be real. Indeed, with the terms CorpTech, we usually refer to all the technological solutions that usually are applied to a corporate governance system. That is to say, in the use of DLT within all the company life. Indeed, scholars, but also companies, has in these years advertised the possibility to do almost everything with blockchain. When we want, for example, the registration of company shares on a public blockchain, the possibility to vote using tokens, but also the possibility to automatically record the balance sheets within a blockchain. What we want to do with this paper is to check, according to Italian company law, if all these solutions can actually find application in real life. We will focus. Two questions that relates to the three topics that we anticipated before. The first question regards the possibility to issue equity tokens according to Italian company law. Then we will talk about the possibility to exercise economic or administrative rights using token. And with regard to the third topic, for us it was not necessary to provide a specific question on this. We wanted to go straight and provide directly a specific solution for the use of DLT for meeting with the means of distance participations. So, going to the first part of this paper, we will analyze the possibility of issuing equity tokens according to Italian company law. We wanted to focus on Italian company law just to give some practical results that can be find application as for today, considering that this is the law still applicable if you want to open a company in Italy. To see if equity tokens can be issued, and when we talk about equity tokens, we refer to tokens representing shares or quotas participation, so company participation embodied within a token. We have to consider how share and quota are issued. That is to say, how participation are represented and can circulate according to Italian company law. To do so, we will analyze the 4 different regimes, 2 applicable to company limited by shares, Italian SPA, and 2 applicable to limited liability company, Italian SRL, Società Responsabilità Limitata. So let's start with the first one. In the first regime, the one of securitized shares, in Italian azioni cartolarizzate, the shares are incorporated in physical documents. This means that usually when we transfer the documents that incorporate the shares, we immediately transfer also the ownership on the specific participations. So if we wanted to try to issue equity tokens, we can imagine the possibility of incorporating shares within token as we do with physical documents. Although we find some difficulties in doing so. Indeed, the physical documents that can incorporate as shares, according to Italian company law, must possess all the characteristics of accredited titles. Between these characteristics, there is also the possibility that these documents, the things in which we can incorporate the shares, must be something physical. And we have some difficulties considering tokens as physical, considering their virtual nature. So our answer here is that tokens, because tokens cannot be considered as credit titles, for us it's difficult to think that in this regime, if a company desires to issue shares, those shares can be issued using equity tokens, considering the fact that shares cannot be incorporated in tokens because tokens does not have, until now, for our current regulations, the possibility to be considered as credit titles. A different solution maybe could be found out if we consider the second regime applicable to company limited by shares. That is one of non-securitized shares, so azioni non cartolarizzate. In this case, shares are not incorporated in nothing. Indeed, the circulation and the existence of shares is regulated only by the shareholder book that is kept by a company. If I want to trade the share that I own in a specific company that has opted for this regime, I just need to agree on the transfer with the other party and then do a specific notification to the company that will record the transfer on the shareholder book. Now, considering that the shareholder book from 2011 can be kept also using electronic means, we can theorize the possibility to create a shareholder book using a smart contract. If we do so, maybe in this regime it will be possible to issue equity tokens. How we can do that? We need, first of all, to create a smart contract, and for the company, that smart contract need to be the shareholder book. Then if we program the shareholder book with the task of updating himself and with the task of intermediating the transfer of the equity tokens that I have issued, we can have a system that automatically updates the shareholder book, so satisfying the requirements provided by the law, at the same time giving us the possibility to issue equity tokens. Although, and this is quite important, in this regime, equity tokens will not be considered as the shares. Indeed, here, equity tokens could be only considered as a mean of communication. So as an instrument to communicate to the company our intention to transfer our share. This is because in the regime of non-securitized shares, shares cannot be issued. So shares cannot be incorporated in nothing. And so they cannot be neither incorporated in the equity tokens. So we can issue here equity tokens, but those tokens need to be considered only as mere instruments to do the communication required by the law. This means that if I create this informatic infrastructure that represented here, and if I decide to transfer my equity token without passing through the smart contract with the task of intermediating all the trades, I am not passing the ownership of the shares that those equity tokens represent. Because to do so, I have to do the notification to the company so that the data, the information of the new token holder are recorded in the shareholder book. Without this notification, the transfer is not valid in front of the company. A similar solution could be created if we consider the regime of società responsabilità limitata. The first regime is the most used, the most known. It is the traditional regime. Here we have two main problems. First of all, also for limited liability company, shares cannot be incorporated in nothing, cannot be incorporated in documents. So here the circulation of companies' participation is just regulated by the company register. So if I want to transfer the quotas that I own on a specific SRL, I need to do a specific notification to the company registers so that the transfer could be effective. In addition, this notification needs to be done by specific intermediaries, such as a public notary or a chartered accountant. In Italian, a dottore commercialista. These two aspects characterize the system has to be too much centralized and too much intermediated. And this is against the principle of decentralization that characterizes the implementation of a DLT system. However, if we want, maybe we can create a system that is similar to the one described before for SPA in the regime of azioni non cartolarizzate. Indeed, we can create the same smart contract with the task of intermediating the trading of the token that I issued that will represent, quoting represents, the trading of those equity tokens. And I could program the smart contract to make the notification to the company register. However, I also need to exploit the authorization of a notary or of a dottore commercialista to do this notification. In theory, considering that those notifications are usually done using electronic means, indeed the notary or each commercialista uses a program. They have credential with the company register to do these notifications. From an informatic point of view, I could create a connection within the smart contract, the authorization to do this notification of the notary, so that automatically I can reproduce the same effect that the law requires me to do to transfer quotas of SRL. However, also in this case, this solution will not incorporate the right of the participation within the token. Also in this case, I can issue equity tokens, but I have to know that those equity tokens can be used only as an instrument to do the notifications and the communication required by the law. A simple results can be found out also if we consider the so-called alternative regime. Although this regime is not so important if we consider how much it is used in Italy. This regime was indeed introduced in 2015 with the precise scope, with the precise aim of fostering equity crowdfunding development. Indeed, SRL was the most used legal form for participating in an equity crowdfunding campaign, but after acquired quotas of an SRL, each investors had the problem to transfer those shares, those quotas, considering that the transfer of quota can be only done with the described with the means that we have described before. So for this reason, in 2015, the legislator decided to amend Article 110 of the Consolidated Financial Act, introducing this alternative regime. In this case, in order to cut all the communication that should be done to the company register, this regime lets a private intermediary, that usually is an intermediary authorized to provide investment services, to be the only one that is recorded within the company register, and the one that results as the only shareholder for that company. In this way, each shareholder that after an equity crowdfunding campaign decide to opt for this regime has just to do a notification to the intermediary and not to the company register with the needs to contact a notary or a chartered account, as we have seen before. In this regime, so the private intermediary, being a private entity, it's free to adopt each system that he wants, each electronic system that he wants to manage the transfer of shares and quotas. And so you can also use a DLT system. So also in this case, tokens can be issued, but only as a means of communication. If we want to sum up the first part, to the answer of our first question, the answer is no for the first regime of azioni cartolarizzate. It is yes for the other regime applicable, although it is more difficult to do so for the traditional regime of SRL. For this reason, we write that maybe. Although in all this regime, an equity token will never represent the shares of or the participation of that specific company. Here, equity tokens, according to the law, could just be used as means of communications. The solution to let a tokens be in itself to represent in reality the shares of a company would be to amend rules regarding credit titles in order to let a company to incorporate participations of company within tokens and not only in physical documents. So now we can go to the second part of the paper. It regards the possibility, analyze the possibility of exercising economic and administrative rights using tokens. When we talk about economic rights, we refer to the simple right of receiving dividends. Indeed, a company could, for example, decide to distribute automatically all the dividends accumulated during the year when it reaches a specific number of votes, and vote exercised by a specific token that is given to its shareholder. And while with the administrative rights, we usually refer to the right to vote, that is and the right to intervention, so the possibility to speak up within during a meeting and having our intervention be written down within the minutes of the meeting. So when we deal about the possibility of exercising economic rights using a DLT system, we will not find out any legal limitation, at least ex ante. So from this point of view, a company is kind of free to adopt each DLT system that it wants to distribute automatically dividends, assets to their shareholders. Shareholders that are qualified as so because they hold a specific tokens. Although this does not mean that there are no limitations at all. Indeed, we know that DLT implies the impossibility to claim back distribution. we know that when we transfer something using DLT, for example, Bitcoin, Ethereum, or whatever, we are not in a position to request it back, nor even asking to do so to a judge. There is kind of impossibility to know the private key of another person so that we can move the assets that we transfer to the other parties. In this way, we know that there are some occasions in which during the company life, distribution of assets can be claimed back. For example, during a bankruptcy procedure in order to satisfy the back condition creditor. So if there is no implementation of a mechanism that could let a distribution to be given back, the director that decides to implement an automatic mechanism without providing this mechanism could be responsible for having implemented a mechanism of this such. Another problem with the exercise of economic rights is the need to create a link, a practical link between a banking account of the company and a DLT system. Indeed, if considering that a banking account is off-chain and the token or the wallet in which I can receive cryptocurrencies that has been promised to me, creating an automatic mechanism as the one described, considering that this is on-chain, if I don't have a strong bridge between what is on-chain and what is off-chain, it is like that this mechanism has not been implemented, because a director could just corrupt the bridge, the link between what is on-chain and what is off-chain to nullify this automatic right that has been given to me. So maybe in this case, for the exercise of economic rights, while there are not legal limitations, at least ex ante, there are maybe some technological limits in the implementation of such mechanisms. A similar solution can be found out with reference to administrative rights. Here, there are no legal limitations at all. There is just the need to write down on the bylaws about the possibility to implement a voting system using token or DLT. This is the only legal provision about the introduction of such system. But there are still some strong technological limits. Indeed, we have a problem, for example, on deciding which DLT we want to use to implement such rights. For example, if I decide to implement a permissionless DLT, I have to know that the transparency of this DLT will let everybody to see all my voting results. The same for the right of intervention. So if I want to digitalize the minutes of shareholder meeting of a company directors, I have to understand that if I use a permissionless DLT, everybody can see what I say during that meeting. On the other hand, if I decide to use a permissioned DLT that is less transparent, I have the problem to decide who has the power to control the node, and so the miner that will maintain and that will give power to this DLT. Because if I choose the wrong miners, they can actually modify the voting results before a meeting. So I have, in this case, I will not have any kind of benefits of applying this system. However, maybe there is a solution that is still that we still let us implement a permissionless DLT, and this solution may be the possibility to record on a public blockchain, on a permissionless blockchain, just the hash of each single voting pool. In this way, I can verify ex post, thanks to the hash, if the voting has been changed during the process or not. Finally, in the third part, we just provide a solution. Indeed, we find out that a DLT is a kind of necessary instrument, or will be within few years a kind of necessary instrument for participation at distance. we know that now participation at distance is required also by the law, considering the health emergencies that we are seeing today. But, and until a few years ago, we have no problem with that, because we considering the fact of the possibility of seeing a person's face and of hearing his voice as a guarantee that the person that was speaking was the real person that was legitimate to participate to those meetings. Now, this guarantee, we can say that is not so strong. Indeed, deepfake, so-called deepfake technologies can nullify at all this guarantee. If you want to understand what is deepfake technology, maybe if Francesca agrees, I can show this brief video. It's just 1 minute or less.
Just what 1 minute.
Yeah, I can show just 10 seconds.
We have to be in time.
As you can see,
hey guys. I'm Elon Musk. Yes. Looks like I got into the wrong conference zone. How are you doing, guys? Good. How are you? I'm nice. This is amazing. Nice hair color, by the way.
so this is one of the most famous examples of deepfake technology, in which during a private conversation between two guys, an hacker bumps within this conversation wearing a digital mask of Elon Musk. So the one that was speaking over there was not Elon Musk, as you can understand if you see the video more than one time, but the face that those guys can see using this program, the deepfake technology, can adapt in real time using the voice and the face of Elon Musk. This put in danger all our belief on what we see after, on what we see that is behind a camera. Here, the solution could be. Okay, we can cook. The only solution to a technology that can alter everything, also video in real time, could be maybe only a technology that cannot be altered, such as DLT and the possibility to use identification tokens. For example, if before the election of companies' directors, we will give them identification tokens that are connected using, for example, biometrical data to them, and those tokens cannot be transferred to nobody. We will just need a smart contract that can react to that identification tokens to confirm their identity, so that we can be sure that on the other side of the camera there is not an hacker or someone like that, but there is the one that is legitimate to participate to this reunion. So to conclude, if we want to answer the question to if the CorpTech myth is real, maybe the answer is that it is not real yet. Indeed, as we have seen in the first part, there are still some legal obstacles to the possibility to apply the DLT system within a company's life. On the other hand, as we have seen in the second part, with the exercise of economic and administrative rights, there are also some technological limitations to do so. While in other occasions, there are no limitations and there are still some concrete solutions that are ready, as we have seen for deepfake technology. So what we can do about it, we can obviously update the laws in order to let, for example, tokens to be to have all the requirements provided for credit titles, and so we can issue shares within tokens. We can also innovate technology, for example, creating strong links between what is on-chain and what is off-chain, for example, to connect a banking account to the wallet of our shareholder, but also, for example, we can just change our behavior if we want to adapt these technologies as for today. Indeed, for example, if we will start globally to use more cryptocurrencies, we will not have some technological problems are the one that are connected to the needs to create bridges between on-chain and off-chains. If the dividends of a company can be accrued in cryptocurrencies, the company could automatically share them without any technological problem. So thank you. That's all. If you have any questions, please, you can write to this email. Here there is just some references so that to go in deep to some of these Italian law specific problems. Thank you.
Thank you to Salvatore for your presentation and also for this attempt to apply this blockchain technology to the company law. And also thank you for this video that has shown us the risks involved in this kind of new technology. And now we have finished the presentation time and we can move on to the question and answer. So there are any questions? I remind you that you can use, that you can write on our chat or just raise your hand and we will open your microphone as soon as possible. Okay, I have seen a hand. Sorry. Okay. Okay. Hello, Nicola Massena.
Hello.
Your microphone is open.
Thank you for the interesting panels. I wanted to ask a question regarding the crowdfunding platforms and the possibility to turn these crowdfunding platforms into STO platforms, in particular with regard to the new EU regulation concerning crowdfunding that will enter into force next year. And also with regards to the fact that the Italian Financial Authority in his paper, consulting paper, prefigured this kind of opt-in regime in which the crowdfunding platform could act as security tokens platforms. Thank you.
Okay, thank you for your answer. I think that maybe Salvatore can answer this question.
Yes. Actually, the rules that will be implemented refers to the process of opting in provided by Consob, but also the European regulation could help the possibility to issue to do ICO using equity crowdfunding platform. Although, if actually, if you analyze the equity crowdfunding discipline, you can see that it is possible, as for today, to do an ICO using the equity crowdfunding rules that are today applicable. So the answer, I think, it is yes, that with the innovation, the possibility to use a platform to conduct an ICO will be, I think, implemented. Although also today, in my opinion, for what I studied some years ago, the equity crowdfunding regulation that is now applicable, I think that is open to launch something that is really similar to an ICO, or if it's an ICO.
Thank you very much for the answer. I'm satisfied.
Good.
Thank you. Any more questions? No, I don't. No. So in this case, I will make some question, and I would like to ask in particular, and first to Riccardo, what is his opinion about the new regulation proposal, European regulation proposal on crypto asset markets, and in particular with reference to the topic of his presentation about the token classification introduced by this regulation?
Sure. In fact, I had prepared some extra slides which feature some appendix that is also included in my article. So I think if we have some time, because I mean the next general panel is
yes,
so I won't take too long, but I can start. I mean to share them again and go directly to the end.
Thank you. We have time.
Okay, thank you. I will try.
You are only three speakers, and so we can use this.
Yeah.
time.
Okay. Thank you. Thank you. Appreciate. Yeah. So the new proposed regulation on markets in crypto assets was already mentioned in one of the presentations, I mean, I see more flaws than good ideas, to be sure. I mean, to be honest, in as far as the terminology issue is concerned, first of all, I mentioned earlier the risk of falling into the circularity trap. If you look at the proposed regulation, you see that no definition of security tokens is provided. So it's really confusing. I mean, at least the first 5 times you read it. I mean, security tokens they appear to be included in the general definition of crypto assets, but then they tend to be identified as the tokens that qualify as financial instruments under MiFID II. So, I mean, from the general definition, they seem to fall under the general category, but then they explicitly fall outside the scope of the regulation. So it's really not clear if the definition is comprehensive. Certainly, the proposed regulation is not comprehensive because it explicitly leaves out some categories and above all security tokens. Then you also have some problem as regards electronic money or e-money. It is defined with a double negative, which is never a happy drafting choice, in my opinion. It says that the regulation is not applicable to crypto assets that qualify as e-money, except if they qualify as e-money tokens under the regulation. So I really think that you need to read these sentences several times before actually understanding what they meant. But I mean, so on the one hand, the regulation doesn't apply to e-money, but it applies to e-money if the token qualifies as e-money under the regulation. So I see again some circularity here and some lack of clarity, which is kind of unusual if you think, because I mean,
Riccardo, sorry, just a question. I can't see your slide. Are you sharing the screen or not? Because
I'm sorry about that.
I can see.
I'm sorry.
I don't know.
I started the presentation, but probably sorry about that. Why don't I immediately? Yeah, absolutely. Apologies.
It's my fault.
No, it's my fault. I mean, okay. Yeah, let me fix it immediately.
Now we can see.
There you go. There you go. Yeah, I mean, it's good to read it because it's difficult even if you have it in front of you, and you can read it even more if you actually have to just listen it. Anyway, I was just at this third point of my slide. So the definition of e-money tokens is a bit puzzling. So it was my third point. Finally, there's a very strong focus on stable coins. I mean, you can question it from a policy perspective, but still, that's not the point. They focus on stable coins in the explanatory memorandum at the beginning. They speak a lot about stable coins, but then the category is not developed in the proposal, so it doesn't feature in the proposal. So it's quite confusing from this perspective. So you expect to read a lot about stable coin regulation, and then it's not a self-standing category. When it comes to definitions, in any case, you see that there's a general definition of crypto asset that, I mean, I have not much to comment about. They are described as a digital representation of value of rights, which may be transferred and stored electronically using distributed ledger technology or similar technology. And the reference to DLTs is indirectly covers the issue of cryptography. So it's not present here in the crypto asset definition, but it indirectly comes into the picture through the reference to DLTs. Security tokens, as I said, they seem to be covered by this general definition, but they are explicitly outside the scope of the regulation. And as for cryptocurrencies, they seem as well covered by this general definition, but they are subject to a specific regime. As for the subcategories of the broad category of crypto asset, the proposed regulation mentions three. It mentions asset reference tokens, electronic money token or e-money token, and utility token. But they appear not to be the only existing ones. So again, how about security tokens? It's quite puzzling to have a new, you would expect that the new regulation would be comprehensive, but instead it is not. Actually they declared at the beginning that crypto asset and distributed ledger technology should be defined as widely as possible, and I agree with that, to capture all types of crypto assets, but then they say which crypto assets which currently fall outside the scope of union legislation on financial services. So to a certain extent, similarly to what the SEC was doing, they seem not to be very much concerned with structure and with I don't know, systematic clarification. They are simply concerned with with the outcome, with the regulatory outcome. So considering that security tokens are already covered by MiFID II, by financial services regulation, we simply do not care about them here. We only care about tokens that are not covered by already existing financial regulation. And I think this is not a wise policy choice. There are some other problems. So asset reference tokens do not correspond to the asset tokens of FINMA. They are a type of crypto asset that purports to maintain a stable value, etc., etc. And you also see the reference to stable value in the definition of e-money tokens. So you would expect to find some reference to stable coins here, but you have two definitions of tokens that talk about stable value, and then you have no reference about to stable coins, in spite of the insistence on stable coins on the explanatory memorandum. So it's quite confusing. There is a definition of utility token. It's simply a type of crypto asset which is intended to provide digital asset to a good or service available on DLT and is only accepted by the issuer of the token, which is good because it avoids circularity. They appear to be a residual category, like it was the case with the SEC. The problem is that the expression utility tokens, as important as it is, only appears 4 other times in the draft. And the Title 2 of the draft regulation that is dedicated to what one would think that it is dedicated to utility tokens. Instead, its title says crypto assets other than asset reference tokens or e-money tokens. So it appears that there are tokens that fall into this category that are not utility tokens, but you are left wondering which tokens are these. So I think there's a wide margin of improvement in what the Commission has done so far, and I hope in the next steps of the legislative procedure, some amendments will be taken into consideration at least fix some of this remaining confusion. Thank you.
Oh, thank you very much, Riccardo. I agree with you about this difficult choice about the definition of token used by this regulatory proposal of the European Union. But we will probably talk about this issue also in the next session in the general panel. We will see. It's just, I think that this is just a first step towards achieving an efficient framework for crypto asset, and especially from the point of view of the tokens classification, with it's a very, very hard topics to solve in this way. And also this problem concerning the use of the notion of stable coins, and in the proposal at the end they choose to share this notion into different subcategory, the asset reference token and the e-money tokens, and not to use the stable coin. I don't know why, but it's very particular. And also the choice to not define the securities token, and instead to adopt another regulation just for the secondary market. And probably we will have to wait the innovation and the amendment on the MiFID directive concerning the definition on financial services. In this case, probably they will better explain and describe the concept of financial insecurity tokens. So I have already seen, okay, there is another question from, oh, I'm sorry. You can speak?
Yes, thank you.
Oh, sorry, I have some problem with this kind of technology. Sorry.
Just a brief comment of what has been said before. I agree that has been a missed opportunity, this legislative initiative of the Commission. I also think that there is a clear reason why. I mean, the topic of stable coins and the threat to the sovereign power of states to print money attracted and the attention of regulators really deeply. But I think that also the fact that there is a second proposal of regulation concerning, as you just said, the secondary market of basically transferable security issued on DLT is actually a really good thing, and I mean can be really useful in this market. So we could have actually a regulation for trading platforms that actually trade in tokens, basically. Do you think that is a possibility to use this second regulation to do so? To basically,
yeah, I mean, why not? I mean, maybe it's just I mean my personal preference, but I mean I think that I mean, if you embark on such an ambitious initiative, I mean, it would be ideal to have one piece of legislation that covers the whole subject. But certainly, I mean, yeah, that there's this other initiative, and I mean, that definitely, I think it's a good opportunity to provide some responses to some of the points that I've been trying to make. But to be sure, I mean, also within the actual legislative procedure of the MiCA proposed regulation, I think there is still time to make some improvements. I mean, there has been a very broad consultation before that, but there's still time, I think, to for the Parliament and the Council to amend the regulation before it actually comes into force. But certainly, I mean, there's this comprehensive move of the European institutions, and certainly so other options could be welcome as well, definitely. Thank you.
Thank you.
Thank you.
Okay. Just some other questions? So I can ask to Eduardo and to come back to the topic of his presentation, and in particular, can you share your opinion about, also in your case, the new proposal regulation, and in particular the impact of this regulation on the AML fighting? Can you say something about your opinion? Do you think that this proposal can improve the effectiveness of the regulatory framework concerning the AML area or not?
Well,
Can solve the problem that you have underlined in your paper in particular?
Well, it cannot solve the problem that I've addressed in my paper by itself, because the regulation is very clear in stating that the AML standards that will be applied to both the issuers of asset reference tokens and the crypto assets exchange services are those deriving not from AMLD4 itself, but from the national AML legislation implementing AMLD4. And in that regard, as I've tried to show during my presentation, there is a lot of asymmetrical harmonization. So if a specific entity is not an obliged entity under a national AML implementing legislation, it's not to say that they are not at all under AML obligations, but the scope for an FIU to act is much more restricted. And okay, there are two more issues that I like to pose in this regard. The first is that issuers themselves is a concept that is strange to AMLD5, or if you prefer AMLD4, because AMLD5 is the modifying legislation. Therefore, there won't be many national AML implementing legislation in which issuers are an obliged entity at the first place. And as I said in the end of my presentation, how can you breach a legislation which does not apply to you? It doesn't make any sense. But on the other hand, the regulation says that if board members or persons involved in the administration of issuers or crypto asset exchanges are personally in breach of AML legislation, then that can also be grounds upon which to withdraw authorization of the entity from functioning. And in case there is an acquisition happening, the competent authority can stop the acquisition and reject it on grounds that somebody involved in management is personally charged with AML crimes or breaches. So it expands a bit the reach for natural persons involved, but in terms of entities covered, I believe it doesn't directly impact on what AMLD5 has already tried to cover, unfortunately, because it was an opportunity to expand the reach a bit more, especially considering that after AMLD5 was enacted, the FATF updated its standards, things that I mentioned during my presentation, such as crypto to crypto exchanges and ICOs, issuers, as the proposed regulation itself says, and are all under the revised FATF recommendations. So as in the same case of the issue that Riccardo was saying, the Commission missed a big opportunity there in my view as well. I hope that addresses your question.
Yes, thank you very much. So also in this case, we will hope for future amendment and maybe adopted by a regulation. So we will address the problem concerning the different way of interpretation by each single state. And so we will, in this way, we will maybe guarantee a more harmonization also in this field, with another instrument, the regulation instead of the directive. So we will see what will happen in the future. Now, I would like just ask a last question to Salvatore, always in the same area, more or less. I'm sorry, but I'm particularly interested in this field, and I would like to know his opinion about the new EU regulation proposal on pilot regime for market infrastructure based on distributed ledger technology. In particular, I would like to know if, in his opinion, this proposal could impact and improve the use of blockchain technology in company law, and in some way can make the might of CorpTech concrete.
Okay, thank you, Francesca. If I have to be, if truth should be told, I don't think that this kind of pilot regulation could enable corporate governance system to be enhanced through the use of DLT technologies. Indeed, this pilot regime applies only to regulated entities. So the only ones that will adopt DLT solutions will be market infrastructure, for example, Borsa Italiana, Monte Titoli, etc. So, okay, this is good, and this is a real innovation to foster in general the implementation and the use of token to represent shares, although they will not solve the problem of making tokens available to the real life. Because if I can tokenize a share, but only if I opt for the regime or the informatic system that is provided by a regulated institution, the system is still centralized. So the real innovation of DLT, that is decentralization, so the possibility that I can have a token, and within this token I can put whatever I want, all the right that I want. This is not a solution that could do it real. So a better solution could be what we said before, the possibility, for example, to amend company law, so letting everyone that wants to tokenize his share to do so. In doing so, you just opt for a regime that is created by an entity, a regulatory entity, and okay, you can do this. You can maybe you will have the possibility to keep those shares in your wallet, in your personal wallet, if you don't want to go to a wallet service provider. But still, those shares can be traded only on that specific infrastructure. That being not a public infrastructure, because there is a regulated entity beyond the infrastructure, this will not, I think, decentralize the system. So this is in brief my opinion.
Thank you very much, Salvatore. So also in this case, it's just a first step, and we need to wait and over in the future to see a real and complete regulation for cryptos asset area that could cover all the issues and give an effective legal framework for this. So thank you very much. Now I think that our section is closed. Now I think that it's time to, if there are no more questions. Oh, I'm sorry. There is no more question, just a communication. No, so thank you. I have to thank you very much again for your attention, and I want to thank the speaker for their presentation, and also our I just want to remind our sponsor, Chexing, the Rock Trading, and Deloitte for their support in the organization of this event. I want also to remind you that at 6 p.m. we'll start a plenary session presented by Professoressa Antonella Sciarroni-Aribrandi, entitled Developments in Crypto Assets Policy and Regulation. And I thank you all for your patience for attending this session. I hope that that you find it interesting and useful, and I hope to see you in the future, not in this virtual way, but in the real life. So thank you very much to everybody, and see you later in the next panel. Thank you all. Bye.